Hear ye, hear ye, Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business in this honorable court are admonished to draw nigh and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Thank you. Yono versus Department of Transportation. You apparently didn't get the time memo.
I'm sorry?
You apparently didn't get the time memo.
Apparently not, Your Honor. Good afternoon, Aaron Lindstrom on behalf of MDOT. I'm joined at council table by Assistant Attorney General Kathleen Gleason, as well as counsel for arguing Aniki, John Bursch, and Gaten Gerval-Riach. I hope to give them 7 minutes and then also reserve 5 minutes for rebuttal.
Manage your own time.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court, this case is about whether or not a parallel parking lane is part of an improved portion of the highway designed for vehicular travel. And that turns on whether or not Mrs. Yono gets to go forward on the merits or whether or not the state is immune. So the relevant language is designed for vehicular travel, and the word designed has at least two possible meanings, and I think the state would be immune under either reading. So if the word designed focuses on an engineering aspect of it, well, even under that circumstance, the pavement markings that separate a parallel parking lane from the other travel lanes are part of the design and the engineering of the road. If you take a look at the Michigan Road Design Manual, which is about a 3-inch binder, the very first section of it points to another manual that talks about construction specifications, and it also points to another manual, which is the Uniform Traffic Control Device Manual, which is this 3-inch binder I have here. So it's such an integral part of the design of the highway that there's a 3-inch binder designed specifically for traffic control devices, and pavement markings are a type of traffic control device. There's something that indicates where traffic is supposed to go and not supposed to go. So another way to think about the ordinary meaning of the word engineered, if you thought this means engineered for vehicular travel, even in the ordinary sense, if you put markings, that goes to the engineering of something. So for example, if there's a facility that owns 2 plots of land and they cut down all the trees and they level it and they plant grass, and on one of those 2 they draw lines to show it's going to be a soccer field, and on the other one they don't, you would say that one was engineered or designed to be a soccer field, and you wouldn't say that about the other one. The other one might be a pasture or a park or something different. So even in the ordinary use of engineered, it doesn't focus just on physical aspects. It also focuses on pavement markings. The other possible meaning would be if it's intended. It's intended for vehicular travel. And again, pavement markings are relevant to that too. That's how MDOT and how the state tells people where they're allowed to drive and where they're not. So under either meaning of the word designed, it focuses on whether or not something is in a travel lane. It focuses on whether or not it's where the cars are supposed to be driving. And to the extent there's any doubt about which of these 2 is the one that's narrower or broader, there's a canon of construction that this court always applies in cases about governmental immunity, which is that immunity is broad and exceptions must be narrowly construed. So if you disagreed with the engineering and thought engineering only meant the physical characteristics, then you'd have to pick the intended definition, because pavement markings definitely go to intent. So those are the basic reasons why the canons of construction and the plain language both point in the same direction, in recognizing that a parallel parking line that's marked off by paint, say don't drive here, is something that is not a travel lane. And that phrase travel lane is what this court focused on in the Grimes case, which was about the shoulder. It looked at whether or not a portion of the highway that's designed for vehicular travel is a travel lane or not. And the holding in Grimes says, we hold that only the travel lanes of a highway are subject to duty of repair. So that's consistent with the plain meaning of what you would think a travel lane is, and it's also consistent with the manual. The traffic device manual says that the traveled way is exclusive of parking lanes. So I'd be happy to waive the remainder of my free fire time if I have any.
Well, you can certainly travel on these parking lanes, right?
In the same way that you could travel on a shoulder into Grimes, yes. You could have some incremental movement that would be travel in the ordinary sense of the word.
But it's not exactly the same way, right? Because a parking spot is sort of the beginning and the end of your route of travel, and the shoulder, when I map out my route of travel and I'm starting parked on M22 in Suttons Bay and I'm going to drive to Traverse City, the parking spot is the start of my travel route. Never in that route is the shoulder part of it unless I have an emergency. Isn't that fair to say?
I would say you're generally trying to stay off the shoulder. I would agree with that.
I mean,
that's better driving.
Right. But the travel lane I'm invited to travel into and to travel out of. Is that
Parking.
also true?
Parking.
Parking is intended for you to
That's what I meant.
move your car some incremental distance, but in the sense of what is travel, again, this court focused on the fact that there has to be some portions of the highway that are not designed for vehicular travel.
Totally agree. But I think you can. I mean, I'm just trying to figure. I wasn't here for Grimes, so I just have to read it like I'm like a law student, and in probably a move of judicial restraint, it didn't end up defining travel. But it did say what travel was not, at least in terms of the shoulder. And for this reason that it's just incremental movement, it's also emergency movement, right? I can't be driving along 96 and see a speedway and think I'm just going to pull over on the shoulder and cross the grass because it's more convenient for me.
Right.
I'd need to run out of gas or something. I'm just trying to figure out what incremental movements count and what don't. The center lane, if you're turning, you would concede that's travel.
I would concede that a center lane when you're turning is travel, or
A left turn
right-hand turn lane, a left-hand
Why?
turn
A
lane, an
ramp.
exit ramp. Because that is part of the travel, that is part of the route you're on. But the
Is that part of the way the road is designed?
I think it is. It's expected that the line of your travel will not necessarily always be a straight line. And
Isn't it
so
designed to traverse so that you can make a left-hand turn to move into the turn lane? That's not part of the conscious design of the road?
I think it is part of the design of the road that you can travel and traverse a left-hand turn lane or right-hand turn lane. And I think that this focus on, again in Grimes, this court talked about the travel lanes. And I think that is very instructive. One of the purposes of this court's...
Here's my concern. Who gets to design, given that this is the statutory reimposition of the common law doctrine of sovereignty that this court, for its own reasons, jettisoned, given that we're really talking about state sovereignty, and as you point out, the immunity is great, exceptions are narrowly construed. Who gets to design and who gets to second guess the design in this context?
Mm-hmm. Well, the legislature gave the design task not to the courts, but to MDOT. There's an agency created to design roads and to govern that. So that would be the first starting point. And part of its design includes thinking about what's the traveled way and what's not. And this court emphasized the traveled way. I mean, one great thing about that from a sovereign immunity point is that one of the goals of this court's case law over the last 15 years has been to provide some clarity so that it's a bright line where you can tell when it applies and when it doesn't. And focusing on a travel lane does that.
Here's the point. There are media, road media, that may be indistinguishable given travel, parking, or, for that matter, shoulder. What I'm trying to figure out in this case is who gets to say what is a travel lane and who gets to challenge that.
Mm-hmm. And I think I want to say that paint markings get to decide what's a travel lane or not, right? MDOT draws lines on roads to say here's where you travel and here's where you don't. Here's where the shoulder is. This court has said the shoulder is not a travel lane, and it's MDOT that can draw a line to say here's where the shoulder starts and here's where the shoulder ends. And I think there's actually other specific statutory text in 69.1402 that points to this point. It talks about crosswalks, and the legislature specifically said crosswalks are something that are not within the scope of liability, and a crosswalk is defined only by the paint markings. If you look at the crosswalks that are directly around this court, the physical structure of the road is not any different. It's just that there's paint on it.
So I understand you want us to defer to the paint, and I get that, but ordinarily, so if we talk about the shoulder, there's a white line along the edge, solid white line that tells me that's where the travel lane ends and the shoulder begins. Here we don't have a solid white line. We have these parking spaces. So just saying defer to the paint doesn't tell me what the right answer is, because there's no white line. Maybe when MDOT is telling me you're out of the travel lane is because they drew a solid white line. And
Well,
they didn't. So just saying, look at the paint doesn't tell me anything. I don't know what I'm supposed to be looking for. What's the bright line?
Yes. Thank you, Justice Larson. I think the
Painted line.
Bright painted line.
the perpendicular lines, in this case, if you look at the photos, there's a perpendicular line out from the curb, and it's got a little cap on the end of it, like a serif on a capital I or something. And it's pretty obvious.
Designated parking spots.
That's the parking lane, designated parking spots, and the edge of those lines shows where the travel lane is on one side and where the parking lane is on the other side.
I thought there was that buffer first, according to your affidavit. There's the travel lane, the buffer, and then the parking lane. Isn't that correct?
That's right. There's also a buffer.
So when I pull out of the parking spot, I'm parked on M22 right in front of whatever, some business I just came out of, and I turn my key and I want to drive back to Traverse City, when does my travel start?
I think the point of travel is it's going from one spot to another. I think once you're on the end points of your line, you might think that if you're trying to draw some philosophical difference between where
Endpoints
travel
of
is or
what
isn't,
line?
that's
Excuse me.
a starting point.
What line?
The line,
Endpoints of what line are we talking about?
in the context of travel as a whole, I was picturing it as going from point A to point B.
Okay.
So I was saying the points A and B you might think of are not, I mean, it's metaphysically, how do you say what smallest increment is travel or not? So that's why the court tried to draw an understandable line in Grimes to say we're not looking just at the short distance, we're looking at whether or not you're in a travel lane. And once you're out of the parallel parking and into the travel lane, that's a straightforward, easy line to apply.
But I assume when I'm pulling out of my spot, I turn my key, I start pulling out, half of my car is out. Would you say I'm traveling then? Or does my entire car need to be out of this space? Like what if I'm
trying to think,
halfway
'cause
out?
you'd have the same-
Two wheels are out.
You have the same question, I guess, if you had one wheel on the road and one on the sidewalk, or one on the shoulder and one on the road. So it may be that even if, I think if I hit a defect on the sidewalk when I'm driving half on the sidewalk and half on the road, then that's not MDOT's responsibility in the
But
same
Counsel,
way.
don't think it is.
but I have a
Yeah, I
question
agree
though.
with
Here's my question. Based on Justice McCormick's question, if I'm not traveling, what am I doing? Which is ironic since I don't drive. I love trying to figure this case out. It just makes it so much fun because I don't know these things. I don't drive, but which I think you should all be happy about. But I guess the question is, if I'm not traveling, what am I doing?
I would say you're
You are
coming.
traveling, but you're not in a travel lane, right?
I think that'd be
traveling
the
out of
first
the
answer
travel
is you've left the travel lane. So under the meaning of the statute, it's not travel. Just like once you pull into a municipal parking lot, you're still traveling in the sense of the word travel, but you're not within a travel lane, which is what this court focused on.
And so is the buffer part of the travel lane? If I'm going through the buffer to the main travel lane, am I is the buffer part of the travel lane? Or no?
Well, a buffer zone, under the road design manual, there's a specific width that the road goes over.
Yeah, I read that.
So that would be the 22 feet across it, and I think that's right. So
Yep.
that means if you were driving down a country road and you were farther over, you'd be on the shoulder. And this court has said that the shoulder isn't.
No, on this
So-
road, because your affidavit said there's the travel lane, the buffer zone, and then the parking lane. And I think I have to get from my parking spot to the travel lane, I have to cross the buffer zone. When I cross the buffer zone, is that also not a travel lane?
It depends on how far the buffer zone is from the edge, and I don't know the factual answer to that off the top of my head, so I can look at the affidavit.
What does the statute immunize and what doesn't?
What it immunizes is the portions of the highway that are travel lanes. Those
Okay.
are the areas that
All right.
are relevant.
According to you, what are the travel lanes on this road?
So we would say for Sutton's Bay, the travel lane is the part most cars would be driving for, just I don't know what to call that, but the travel lane. And we'd say that the parallel parking is not a travel lane. That's not where cars would be expected to travel. And the buffer zone, I think, could be like the shoulder, where it would depend on how far over you were.
What
before
are
you
buffers
knew.
up
What
in
did
here?
you just say?
There's the part in the middle between the parking and the
I
travel.
understand. What is the buffer a travel lane?
I think it depends on whether or not it's like the shoulder or not. And I think that depends on how far from the edge you are.
I have
So-
no idea what you just said.
I don't understand. So here's like some grass and a curb. Here's my parking, which is marked by those little eyes. Over here is the travel lane. As Justice McCormick's explained it, there's a spot in the middle.
Sure.
So I don't understand this. How close is it to the edge? What, to the edge of what?
I'm talking about it in terms of design, but I guess I would say that the buffer zone is something that you're allowed to travel on. So I'll just say the
So it
buffer
is a
zone
travel lane.
is a travel lane. But
Okay,
the
so
parallel
not only
parking is
travel
not.
lanes are travel lanes,
I
some
didn't-
other things
Don't mean
are.
to sidetrack us by talking about the buffer zone. So the parallel parking lane, however, is not a travel lane.
Why? Is it designed for vehicular travel, like the buffer?
I would say it is outside the travel lane under
Why?
Grimes. Because if travel lane means anything, I think what this court was trying to get at, it's where the cars are expected to travel. That's a word that MDOT understands and
Exactly.
uses.
The whole phrase is designed for vehicular travel. The question then is, can the state, by putting in designation striping, indicate where the travel lane is to be and where it is not?
Is there anything to be learned from MCL 257, which I'll paraphrase as describing the part of the highway on which vehicles are moving in substantially continuous lanes of traffic? Does that roughly define the difference between, a border, a shoulder, a parking area, and the improved part of the highway? Is there any relevance to that language? It's not used in that context necessarily to define the improved portion of the highway, but it seems to describe that part of the highway where passing can occur and where certain kinds of left and right lanes can occur. Is there some relevance to that language as to the questions you're being posed here?
I think it shows what the common use of it is. It shows, so for example, you're talking about 257.637.
Yeah, substantially continuous lanes of traffic where vehicles are moving.
I think that language is helpful, and I think also, if you look at subparagraph 2, where it talks about the main traveled portion of the roadway, both of those are ways of thinking about what the traffic lane is. It's the substantially continuous lane of traffic, or it's the main traveled portion of the roadway.
So what if it has dual uses?
And I think it does depend on the marking. If there's marking that says it's a parallel parking lane, then it's within the area that's not designed for travel. The places where there's dual use, there's not markings on the pavement. They put signs up as opposed to putting it in the pavement, to indicate that during times of the day it's perfectly fine to drive through those areas, because they were worried that if people saw the paint, they would not drive through those areas.
So can I ask you a question? If I were to so there's no cars parked in those parallel parking spaces. It's Christmas Day, so all the stores are closed, and I just decide, the roadway is crowded because everybody's going to grandma's for Christmas dinner, so I decide to drive in that what you're calling the parking lane. Is that illegal?
Yes, under the statute I was just talking about, which is 257.637, and here's what it says.
0.637?
0.637, subparagraph 2. The driver of vehicle shall not overtake and pass another vehicle upon the right by driving, I'm going to skip a few words so we focus on the right thing, by driving off the main traveled portion of the roadway. And if you were by yourself in Sutton's Bay and there was no cars in sight anywhere except for you had the road all yourself, you wouldn't drive in the parallel parking lane that has lines. You would drive, I think the main traveled portion of the road would be the main lane. That's where everybody would drive, especially if they had a police officer behind them.
So if the paint markings, I follow, because within the paint you really are primarily supposed to park. You're not, you do have to travel in and travel out, but I think the paint markings certainly are indicative of the design, that they were designed for parking. I disagree with the Court of Appeals on that. But how do we know, I think this is what Justice Bernstein was asking, how do we know that that means they were exclusively designed for that? That's what you're saying is the difference between paint markings and signage, and that's the
difference. I think it matters. It shows what the design is. If there's it shows it's not designed to be a travel lane. And if I could, I'd like to save some time for amicus.
Okay, but one more. If you're in the first spot at the front of the block and you just want to turn right and there's no parking spot ahead of you, and I cross over, once I'm out of that painted parking spot, even though I'm on the same part of the roadway, am I on a travel lane or not? Because you know that the
Right.
parking, there's like 15 feet or so until the corner that.
Right, maybe marked by yellow on the curb or things like that.
Yeah.
So I think that area
You're back on the travel lane.
You're back on the travel
Okay,
lane.
so you just want to carve out the parking spots, basically, the painted parking spots.
Right, the places where the pavement markings show that that's not a
Understood.
travel lane.
Okay.
Thank you, Your Honors.
Good afternoon, Your Honors. John Bursch on behalf of AMICI, the County Road Association of Michigan, and the Michigan County Road Commission Self-Insurance Pool. Mr. Chief Justice, and may it please the Court, I want to go right to this concept of travel, because travel can mean a couple of different things. On the small end, it could be the most incremental of movements, and that's what you rejected in Grimes, obviously. On the other end, it could be this broader concept of a journey. I journey from Lansing to Washington, D.C. I don't journey from my kitchen to the dining room. And what Naraki and Grimes and Robinson and Suttles and Horace and all the way back to Ross say is that when you've got a panoply of definitions to choose from in the immunity context, you pick the narrowest construction, the one that will most protect the state from liability. And with respect to parking lanes, I think it's relatively easy to conclude that they do not fall into the phrase designed for vehicular travel. And that is because when a parking lane is fully used as designed, it is full of parked cars, and it is impossible to have even movement there, much less long-distance journeying. You contrast that with the right turn lanes, the left turn lanes, the expressway, maybe even the buffer, where it's designed to have cars constantly moving. So when it's being fully used as designed, there's movement, just like the statute that Justice Markman referred to. And I hate to admit this, Justice Larson, but I actually have been pulled over for using the parking lane to pass somebody who was in front of me. And the reason I was pulled over, did not get a ticket, the reason I was pulled over is because that's not part of the throughfare. It's not part of the travel lane. The other important point, I think, is the one that Chief Justice Young touched on, and that is whose intent.
Before you go to that, you talked
Yes.
about the defining travel, which I'm sort of interested in, and not being the smallest incremental movement. Then the broad definition is journey. I've been trying to plug in these words into the statute.
Sure.
Designed for vehicular travel. So would you say designed for vehicular journey, or is it something else? You know, the way that phrase sets up, I think the word travel is being used as a noun, not as a verb. Would you agree with that?
Just as journey is a noun, I think you could use that interchangeably. And there's actually another phrase that'll help elucidate that point for you. In the very first sentence of this 691.1402 sub 1, it refers to public travel. And we know that can't possibly mean public incremental movement. And that's not what the statute is about. When you step back and take the 10,000-foot view, this is about public journeying from place to place, going from Lansing to Detroit, not the incremental movement in and out of the parking space, just like in Grimes.
If you look up nouns for the word travel, it starts off with things like the act of traveling or passage. It leads into things like movement or progression. And those seem to me words that you could understand this statute to mean. Designed for vehicular passage, designed for vehicular movement or progression. Am I barking up the wrong tree, so to speak, if I go in that direction?
I think because you're narrowing it. At least movement for certain would be too narrow. Some of those other words maybe are a little better.
In the context of immunity, too broad.
Right, too broad in the context of immunity. It works exactly the opposite. Now, we cite the Oxford English Dictionary in our amici brief, and there it does have journey as one of the definitions. And in fact, the Court of Appeals, in its opinion, used journey as its definition, something more than incremental movement, because as the Court explained in Grimes, if you mean something incremental, then you're writing the phrase designed for vehicular travel right out of the statute, because all pavement could be used for incremental movement. So it has to mean something broader than that. And certainly when you talk about public travel, you're talking about a broad concept.
It doesn't actually have to mean something broader, except if you apply the canons of construction in the immunity area. You must preferentially choose the least invasive definition in the continuum of that word travel.
Agree completely with that, but there's more than that here, because there is that phrase, public travel.
Yes.
And if you use public incremental movement, that doesn't make sense. So even if you were going to leave out the canon, which you shouldn't, because it's not just a canon to resolve a tie break. It's a substantive canon that tells you immunity is so important that where possible, we're going to say you can't sue the state. It has to be explicitly set forth in the statute. So, that is important, but we've got the text.
Does that override the plain meaning? When I looked at Grimes, there's a footnote that seems to suggest that the court reasonably interpreted the statute as opposed to narrowly or broadly construing the statute.
I read that same footnote. I agree that's what it says. I think when you look at the phrase public travel in the first sentence, you get to the conclusion that MDOT and the road commissions are advocating. But if you have any doubt about that, you've got the canon.
So public travel means a public journey? I mean, I would agree with you. This movement has to take place in public somewhere, right?
Correct.
On a public highway.
Right, a public journey, a long trip.
So it's a long trip, not a short trip?
It has to be more than incremental movement. The kind of incremental movement you get in the parking lot.
What's a long trip? 10 feet? Is that a long trip? Or
I don't think you can
15 feet?
measure it, because you could drive 100 feet on the shoulder if you had a flat tire. So I think it has to be
So it's
conceptual.
not the length of the journey.
It's not the length.
If it is measured, then it's not the length. Not the time, right?
It is conceptual.
Is it the place of the journey?
That helps. Think about it this way. If I'm traveling from Grand Rapids to argue in this court, I don't have to stop in a parking lane anywhere along the way to journey here. I have to travel on express ramps. I have to travel through left turn lanes and right turn lanes. I have to go everywhere except the shoulder and a parking lane, and I wouldn't even have to go into your parking
You don't
lot.
have to park before you come up here to argue? How did you?
My co-counsel here could drop me off at the door. Or
Did he not have to park?
he could park in the parking lot, not the parking lane.
Wait,
Right,
but
but
what if
soon
we
there's
didn't have
only
a
street
parking lot?
parking.
I mean, what- I think Justice McCormick's point is we don't have a parking lot. We just have the little lanes, just like that we saw in the picture here.
Sutton's Bay.
So, just like in Sutton's Bay. So, when did you stop journeying? I think that's her question.
I stopped journeying. My GPS tells me I stopped journeying when I'm outside the address of the courthouse, when I'm out on the street. And my journey doesn't involve going in and out of the parking space. I want to say
The vector of your trip doesn't end when your car comes to rest and you turn the ignition off?
I think my journey ends when I reach the destination, and that doesn't necessarily mean pulling into a parking space.
What do you do
Again,
with your car?
Well, like I said, it could be dropped off. But the point...
But where does the other person go?
I think the bottom line for the parking lane is if the parking lane is being used as it's designed, it's filled with cars. It's not being used
Wait a minute.
for through travel.
Because it's designed for that we should be focusing on. So if we just want to have a simple, easy to apply rule, we can just look at the paint and we can
Yes.
say, there's a line that separates the white line when it's the shoulder, or it's these markings
Agree
in a
completely.
parking spot. So we don't have to think about how long is my journey. We don't have to answer those questions.
The paint is a bright line because it tells you the designer's intent. And Chief Justice Young, quickly to respond to your question about whose intent, it's got to be the current intent, because how a road is designed to be used, its intended use now, can change. You can have a lane...
My question isn't that. It's who gets to designate?
The government does.
And who gets to challenge that?
The plaintiff can argue, but the government ultimately gets to decide where the paint line is.
If it is the case that the government, and I guess this is an issue, if they paint these little boxes, which
Yes.
are a clear indicator to most drivers, that's where you park, not where you drive,
Yes.
then who gets to say that's not the design of this highway where you get to travel?
That can't be second guessed, because if the government says this isn't for travel, say that it's a shoulder, and the government says this isn't for regular travel, you don't get to second guess that. All that matters are the
Why
markings.
is this different than from the shoulder? Assuming the medium of the road, the improved portion of the roadway is the same, whether it's the intended travel lane or the shoulder, you can travel on the shoulder if it's not impeded.
Right, but if you do it on the shoulder, you do it at your own risk. And that's what the lines tell you. They tell you, this is where it's safe to travel, this is where it's safe to pass, this is where it's not.
You don't
And if you
park
go...
at your own risk.
It isn't-
I mean, that's the difference, right? The at your own risk isn't the best way to to draw.
Well,
this
it is,
line.
because we're talking about a limited pool of government monies. And if there's a pothole in the shoulder, the parking lane, and in the middle of a 70-degree or a 70-mile-per-hour highway
You're
lane,
talking about
you want the money to go into the
consequences
highway.
once you've decided what is and is not the improved portion of the roadway designed for vehicular travel.
What-
I'm trying to point out that it's not the medium,
Correct.
the road medium, it's what is intended to be the traveled roadway.
as demonstrated by the markings. And I'll reserve the balance of the time for my co-counsel.
I just have a very quick question. What is just a bike lane? Like, what if a town or a city wants to make a bike lane? How would you extend that to this discussion?
Obviously, that's not an issue here, but
Yeah,
if
but
it's
it
part of
could
the
be.
traveled roadway, I would assume that it would be covered, that immunity
Yeah, but
would be
often
waived.
bike lanes would be used as kind of an extension, so then how would that be categorized?
As long as it's designed for vehicular travel, which I hear you describing, I think it would be included. Thank you.
Good afternoon. May it please the Court, Chief Justice, Justices. Captain America, in answer to your questions of the body.
Okay, thank you.
Justice Bernstein and Justice McCormick and Justice Larson, your questions bring...
Sir, Counsel, I'm sorry. Can you state your name for the record?
I'm sorry, I thought I did. If I did not, Paige Graves for the appellee Helen Yono. The mixed use of roadways changes all the time by a whim of the paintbrush. I had the occasion last week to take a deposition in Ann Arbor. I'm driving in on Main Street, curb gutter to curb gutter. Because of the paint markings, it's just 2 travel lanes and a center double. I get to West Ann Street by the Broken Egg. Now all of a sudden I have this specially painted bike lane. I have a travel lane and I have 2 lanes coming at me and I have parallel parking. I then get to West Miller where the circuit court is. It's now switched. This is now all a travel lane. Curb gutter to curb gutter hasn't changed. The design of that roadbed surface was and always was, and has always been, I thought, the focus of this court, that we must look at the roadbed surface, paved or unpaved, whether it was designed for vehicular travel. Nothing changed. Mixed use. East Lansing coming into court just this morning. That corridor between East Lansing and the expressway on 127 by the old story Oldsmobile dealership in Frandor, that used to be just 4 ways, and I'm driving on it, and I've been doing this for probably the past 18 months because of the appeal. Everywhere I drive, I'm like, look how this roadway changed. Right there in front of Story Olds. That used to be 3 lanes of through traffic. Now, as I drove it this morning, it's 2 lanes with a siphoned off bike lane. Until you get literally to the end of the old Story Olds dealership, ta-da, it's 3 lanes again for the turn lane. Traverse City is going through its 3rd paint test on 8th Street. Again, changing population, changing behaviors. We're going to more sustainable travel. People want to bike. Lost in all of their weak argument, where does the pedestrian go that Mrs. Naraki established and this court established was permitted to travel on the designed roadway? Justice Markman, you asked about referring to this motor vehicle code. Didn't this court in Grimes, in its very blunt criticism of the plaintiff in Grimes, tell that plaintiff that we do not in this court go to other statutes, particularly the motor vehicle code, to help construe this statute? In fact, I think in Justice Young's writing of this, the Grimes opinion, he specifically showed how you could easily choose one statute in the motor vehicle code, which is at opposite with another, to buttress the argument, and he did so, showing the fallacy in Grimes's argument and for doing so. So I just point that out as to, if you think going to another statute has a meaning, I would caution against this court's own ruling in that regard.
It's not just the markings. If there was a law enacted by the legislature tomorrow saying that no road in Michigan that's more than 75 years old shall be subject to being driven on for the next 12 months until we can improve those roads, wouldn't you agree that those roads that were more than 75 years old would not be designed for vehicular travel at that point? It's not just the markings, it's not just the geometry, but it's also the laws of the state of Michigan. If there's a law of the state of Michigan that says a particular highway shall not be traveled on, it seems to me that fits within the concept of what kind of highway is designed for vehicular traffic.
Your
Honor?
Honor?
Do you disagree with that?
I don't, because for years we've tried to argue other statutes have implication in help defining the highway statute, and for the past 15 years this court has told us don't do that. And now you're advocating we do that. I think that conflicts with Grimes, your own opinion. So where does the pedestrian get lost in all this? We're talking about bicyclists, talking about motorists. What about Mrs. Rachel Naraki, who parked her parallel car, got out, and stepped on the roadway? if a pedestrian is using a crosswalk, which is specifically defined in that statute as an installation outside the highway, they're obeying the law. But if someone is not on that crosswalk and they're anywhere else on a travel lane, they're jaywalking. But can you think of any factual scenario the way they want this outcome to arise where a pedestrian can use a roadway designed for vehicular travel other than jaywalking? No.
Well, you have 2 seconds more.
I'll reserve it to your question, Your Honor.
Your opening remarks struck me as being the perfect illustration of what we all experience. Sometimes the purpose of the road is altered. We add things like bike trails on the side to facilitate greater recreational use of our roads. And how do we know that the purpose of the road has been changed?
We'll find out tomorrow when the municipality or the highway chooses to paint it differently, like they're doing in Traverse City for the third time, because it's not working. Bikers were getting hit being on the right, so they had to go to the middle.
Just a moment.
We don't know where we're going to drive.
When you suddenly encounter the road that has had all travel lanes, and suddenly you have a designated bike lane, you know you don't drive in the bike lane, right?
Today, if it's painted that way,
yes,
correct.
If you have a now painted bike lane, you don't drive in the bike lane, even though yesterday you could.
But
because of what?
No, that is not correct, because right on Main Street in front of the Broken Egg, right in Traverse City, they intersect because they want to allow traffic to turn right, which crosses over that, so they eliminate those bike paths, and they allow it to go straight through.
Just a moment. Where there is a designated bike lane, you know not to drive in it.
When there's a bicyclist, correct, but you can use that lane to continue on if you have to. Now, I think what you were...
Let me ask this. Do you believe that if the road commission, whatever it is, decides they need to have parking, and they put the parking boxes in what might have been a previous travel lane, do you think that motorists get to drive in the parking lane so long as there isn't a parked car there?
It happens all the time, and it was illustrated.
I didn't say it doesn't happen. I'm saying, are you supposed to? Is the city signaling something, or whoever owns the road, something by changing the designation of the lines on the street?
On that given day, it's just like the pedestrian crosswalking. In terms of jaywalking.
Are you really arguing that the motorists should ignore the markings on the highway?
Motorists ignore speed limits.
Okay.
Justice Rivia, I want to leave you with this final thought. In Grimes, we were looking at incremental, random, safety use of a shoulder. But what is parallel parking in municipalities and villages across the land? Daily use, constant, everyday, daily travel use.
Since you raised the point, how would you define travel?
Somewhere beyond Grimes, which would include a parallel parking lane. You start your travel there, you start your ignition, and you convey in and out.
Include some element of continuity of use?
Say again?
Include some element of continuity of use? Is that what I heard you suggesting?
It does, but see, now we're picking winners and losers in an outcome.
I'm not trying to do that. I'm trying to...
No, I'm saying when you insert...
definition of a word in the statute.
We're trying to graft language onto the statute, designed for vehicular travel. Travel starts when you start
I'm asking you how we should define the word.
Well, I thought this court steered away from picking narrow versus broad because the statute doesn't speak of that. It came from Ross. But if we're going to engage in a broad versus narrow analysis,
at our level,
I would advocate a broader definition of travel to include.
We can no longer just criticize other approaches. We actually have to come up with an approach. All I'm asking you is, what approach are you asking us to come up with?
To include parallel parking lanes as a travel lane.
I get your bottom line, but that doesn't answer the question.
Because
sir?
How does it fit within the statute?
How do you get to the parallel parking lane? You travel to it. How do you exit? You travel from it.
So travel means movement.
Movement.
Yes.
Okay.
Can you tell
From
me
point A to point B.
And with Grimes as a qualifier, it's not indiscriminate or temporary for safety. It's an everyday purpose in the cities and villages where those parallel parking lanes have placed them.
Purposeful, intended movement.
Except
Exactly.
on on a shoulder.
Say again?
Purposeful incremental movement except on a shoulder.
Well, that's what you articulated in Grimes. This isn't
I'm trying to
Grimes.
figure out what Grimes does or doesn't apply here.
Grimes applies to shoulders. This isn't a shoulder case.
But Grimes might guide us. I mean, I think Grimes did not give us a definition of travel, but it did tell us what's not travel. And it might be instructive to us in trying to figure out what else is not travel, which may be as much as we can do here. And so why is the state wrong that the painted parking lines are evidence that they were designed, this part of the roadway was designed for parking and not something else?
Because if we go to the core of the writings of this court regarding design for vehicular travel, we look at the roadbed surface, paved or unpaved, and the curb gutter to curb gutter, when that thing was designed and constructed, was for vehicular travel. I started my argument out by a mere swipe of the paint. They can change that in one given day. You asked who gets to make the rules? Obviously, if that's going to be the outcome, this state will always defeat a citizen coming before it under the highway statute. They can paint a straight stripe tomorrow, you're out.
Can you just tell me, under your theory, where is the improved portion of the highway not designed for vehicular travel?
I have to go with the rulings of the court. You've said not a shoulder.
Under your theory.
Say again?
Under your theory of this, of the highway exception, where is the improved portion of the highway not designed for vehicular travel?
According to the court, Grimes.
No, we're actually asking you to engage in a intellectual enterprise. Put aside, look, you're offering a theory. Your theory, as I understand it, does not recognize Grimes. If Grimes didn't exist, you'd say the shoulder, if improved, is designed for vehicular travel, correct?
I think that today, coming down on M115, depending on the paint markings, if we were coming up to an interchange with another state trunk line, what MDOT does is pavement to pavement, they just shift the paint white line over to about a foot towards the gravel, and I can proceed on by, and then they bring the paint line back on.
Right.
Or another 2 miles, they create 4 lanes of passing.
Now let's take that
but
example.
The pavement remains the same.
Let's take that example. That's because they're repairing the road, so they move over, they do something to the shoulder, make sure you can travel on it.
No, that's there today.
Go with me.
Gotcha.
All right. So then they repair the normal lane, and then they put the white line across the separating the travel lane from the shoulder. Is the shoulder any less designed for vehicular travel after they put that white line on than when they were routing you over it during the repair?
No, not at all.
Oh, well,
and I think that's why Grimes should be limited to its holding. I thought you said in this case, Grimes, the shoulder was not designed for vehicular travel. I think what has happened is the appellate courts in municipalities and the defendants, they've taken Grimes and broad brushed it and applied every shoulder when every shoulder doesn't fit in Grimes.
What design means if at one point the shoulder is actually being used, in fact, you're being designated to travel over it, and then when the regular roadbed is repaired, you are precluded by this white line. Isn't that a design change? The composition of the road is the same.
I was going to say, not in the road.
The composition of the shoulder is the same. The only thing that changes is the lining.
Exactly. The roadbed structure has never changed. It was designed for vehicular travel since it was laid.
My question to you then is, your view is that the shoulder is designed for vehicular travel, and the fact that the state puts a solid line saying don't travel over there is irrelevant under this statute.
Not all shoulders, but shoulders where the roadbed surface was designed for vehicular travel, yes, it's always designed for vehicular travel. Okay. The paint markings were limited, or however the court viewed it in Grimes. That's one of the problems with Grimes, Justice McCormick, is we don't have the record before us in the published opinion. But it was clear in Justice Young's articulation of the rule. He said, in this case, this shoulder is not designed for vehicular travel.
I agree, but we're trying to now figure out what it means for the next case. And so I was just trying to figure out what work it should do. And do you have any? Is there anything you can point to in the record that provides any factual or legal support for the conclusion that this portion of M22 that we're talking about was designed for purposes other than parking? I know one of the arguments that's out there is it could be dual purposed, and just because people park there, they could also travel there when, like Justice Larson did on Christmas or whatever. Is there anything in the record, factual or legally, that we could look to support that argument?
Well, there are the photographs from Google that show that happening, and then there's the
I've seen that.
self-evident fact that Mrs. Yono got out of her car and used it as a pedestrian to traverse, in fact, to jaywalk over to the art store across the street. And then, of course, you have the competing experts saying just the opposite of each other, that it is, it isn't. I mean, that would be a coin toss.
Okay.
Thank you.
Thank you. You have 15 seconds.
If you have any questions, I'd be happy to answer them.
I've got one question. I'd like to know whether you agree with me that a highway that has been outlawed for driving for the next week is in fact one that is not designed for vehicular travel. In other words, does the word design, is that essentially synonymous with intended, or is there some connotation to the word design that it refers only to the architecturing, the contouring, the engineering of the highway? In other words, if the law says tomorrow you can't use this road for whatever reason, can it be said that that road is, to that extent, not designed for vehicular travel?
Yes, I agree with you.
Well, Counsel, what if there's no markings? What if it's a long paved area in a downtown area next to stores and there's no demarcations but it's used for parking?
Then in that instance, it's an area, for example, if it's wide enough that there could be 2 continuous lanes of traffic, then that's an area that could be a travel lane. And so the likely outcome would be that we'd be liable. There'd be no paint saying this is not a travel lane.
Even if there are meters, the meters don't
I
send
don't
any
think the meters would,
Yeah, because they're not painted lines.
right. People, when they're driving down the road, don't see there's a meter, I can't drive here.
Right.
Thank you very much.
Thank you.
Case is submitted.